First one was the subject of employment contracts. Okay, so we thought it might be helpful for the restaurant industry and to have on its mind sort of both issues involving the importance of having a written contract in place for employees, and also what can go wrong with that, how to avoid any problems with the drafting and the implementation of an employment contract. So just a few lessons from some recent cases that are relevant to the industry, particularly here in Nova Scotia. So first of all, make a little pitch for the idea that written employment contracts for employees do matter in pretty much every industry, including the restaurant industry. What isn't often recognized is that every time there's an employee and an employer, someone's working for money, there is an employment contract in place. It just might not be a written one. And if there is no written agreement in place, then probably only a few terms have actually been explicitly agreed to, like how the rate of pay, the hours, maybe basic agreement about duties, but everything else about the employment relationship, for example, what happens if the person gets terminated, that's all going to be implied by a court because it hasn't been agreed to explicitly. So, and those implied terms that a court will read into an oral contract of employment usually favor the employee quite heavily. And without a written contract in place, especially with a clear termination clause, then employees in Nova Scotia and elsewhere can often be owed quite a bit if on termination without cause. And that takes a lot of employers by surprise in certain industries. Really, if an employee was there for a long time, they can be owed up to like 2 years of their pay when you terminate them. So a well-drafted contract can give you a lot of control over the employment relationship and over how it ends, what happens when it ends. And just to emphasize this point a little more, the termination clause is really arguably, there are many important things you can have in a written contract, but certainly among the most important, if not the most important, is the termination clause. That's the one that gets litigated the most. There are more court issues about that than anything else. And it's the one that, if you do it properly, can save you a lot of money and clarify a lot for both the employee and the employer. It's also the clause that courts will hold to the highest degree of scrutiny and most likely to be struck down if it contains any errors, like if it's not prepared properly. And there are lots of recent decisions in Canada, including here in Nova Scotia in the past year, where these termination clauses have been struck down by courts who won't enforce them because that high standard of clarity hasn't been met. And so just to give you a few examples of what that looks like and the consequence of not getting it right, little example here. So this is just an example of a possible termination clause you might see in a written employment agreement in a restaurant or elsewhere that says something like, the company may terminate your employment at any time without cause upon provision to you of only such minimum notice of termination or pay in lieu thereof and severance pay, if applicable, to which you are entitled under the Nova Scotia labor standards legislation. So that might look like a pretty reasonable clause. It says, okay, if we terminate the employee without alleging cause, like we're not firing them for misconduct, but if we want to end the employment relationship, we will give you minimum standards that we owe you under the code. And you might think that that's what that clause says, and that means the employer only needs to give what they're required to give under the code, the labor standards code. This is an actual clause that just this past summer in Nova Scotia, the court struck down. Said, no, that violates the employment standards legislation, actually. And instead, the employee was owed not only the 4 or 8 weeks that the employer thought they were owed under the code, but they've been there a number of years and they were in fact owed 9 months of pay upon termination. And it's because they got this clause wrong. And there were actually 3 different reasons, problems with this clause. Not to get too into the weeds with it, but one thing that's wrong with this clause is that according to recent Ontario case law, the use of the phrase "at any time" in an employment agreement termination clause is problematic because it suggests that You can terminate the employee, for example, after they've requested a protected leave of absence, like a maternity leave or something. So the courts say, well, there are times when an employer actually can't terminate an employee without cause, and this would give the employee a different impression. Another problem with this clause is it refers to severance pay. Okay? And in Nova Scotia labor standards legislation, there's no such thing as severance pay. So this clause was pretty clearly taken from an Ontario template where that province's legislation does refer to something called severance pay. It's an extra payment on top of notice that employees get in Ontario in certain circumstances. Doesn't exist in Nova Scotia. So the fact that the employer was using language in the agreement that didn't actually correspond to the language of the Nova Scotia legislation meant that this clause is too ambiguous and confusing for an employee to know what it's even referring to. And so the court struck it down and said the employees owed common law reasonable notice instead. And that was just this past summer. So if you're going to draft, it's important to have contracts in place, but it's also important to get them right. This is kind of a description of those three problems. Often employers don't realize that the legislation, like a lot of employers will decide that they're going to terminate someone and they go to the legislation and they look at the labor standards code and they say, okay, an employee who worked there for 5 years is owed 4 weeks pay. And that might be the case under the code, but what the code doesn't tell you is that the employee could be entitled to a lot more of that too, right? The code is just a floor, it's not a ceiling. Unless the parties have agreed to limit themselves to the minimum standards in the code, the employee could be owed a lot more. It's called common law reasonable notice, and that could very well be months of their pay, as was the case here. Just another example. This was a clause that was struck down in a 2016 case in Nova Scotia. If it becomes necessary for us to terminate your employment for any reason other than cause, it's like serious misconduct, then your entitlement to advance working notice or pay in lieu of such notice will be in accordance with the provincial employment standards legislation. So the employer thought that it had a clause here that meant it only had to pay the minimum standard under the code upon termination. But the court said, well, that's not actually what it says, right? It says that you'll pay them in accordance with the provincial employment standards legislation, but doesn't say that that's all that you'll pay them, right? The minimum that you're required to pay under the code is all they'll get. And so in this case, it said it doesn't clearly limit the employee's entitlements in any way. All it says is that the employer is going to obey the law. And so in this case too, the employee was owed reasonable notice of termination. And what that means for an employer is many months of their pay on termination instead of a few weeks. Okay. One other broad issue, just point out here quickly at the beginning. Let's say you have a new sous chef or someone who shows up, a new manager, shows up to work on June 1st. They work for a couple of weeks, and then everybody decides, oh, well, we went to a webinar. It would be a good idea to have a written employment contract in place. And so you do up a properly drafted contract. It all looks good, and you present it to the employee on June 15th. Well, that raises legal problems too, because once the employee has actually started working, then that oral contract is already in place, right? You've already agreed, okay, you're going to come and start working for me for a certain amount of money, certain hours, and they've in fact started, right? So once the work starts, if you're implementing a written contract after that, that can be a problem. It can be done, but it has to be done properly because in order for a contract to be enforceable, something needs to be exchanged. Okay, and if they already work there, we've already agreed to the basic terms. Introducing a new contract means the employee has to get some new benefit from the contract, right? So maybe a raise or some extra vacation time or a signing bonus. And this was a big feature in a case that our firm actually worked on in New Brunswick for the a healthcare CEO a couple of years ago, where exactly that happened. The parties agreed in a restaurant, actually, to his employment terms. He started working. The written agreement was signed later, and the the court later agreed with the adjudicator in that case that the termination clause in the contract was not enforceable because the employee didn't get anything in exchange for it. It was just a document he signed after he'd already started working. So just a little more detail on these points. The first case I referred to here, just this past summer, in Nova Scotia case called Brocklehurst. This was where an employee who'd worked for 8.5 years. He worked for actually a hospitality and beverage company. He was terminated without cause, and he was offered 4 weeks statutory minimum. Okay, because the Labor Standards Code says if you work somewhere you have between 5 and 10 years service, you're owed 4 weeks pay. So the employer thought it had a clause, it's the first clause we looked at here, that thought that it limited its obligations to that amount, right? Provision to you only of such minimum notice of termination or pay in lieu thereof and severance pay to which you're entitled under the Nova Scotia Labor Standards legislation. But the court, as I explained, found that this reference to severance pay made the whole thing ambiguous because that doesn't exist in Nova Scotia. Might work in Ontario, maybe, not in Nova Scotia. So in this case, the employee, he was actually entitled to 8 months common law notice. So instead of about 4 weeks pay, the court awarded him $53,000, $53,333, based on 8 months of compensation that included his commissions, his tips. So that's a case that just reminds us that in Nova Scotia, like other provinces, courts hold termination clauses to a higher standard of certainty and clarity than ordinary commercial contracts. Okay, they have to be done properly. And then there's this, just a little more detail on what I mentioned, this at any time question. In Ontario now, there's a whole flurry of cases dealing with the question of whether a termination clause can use the phrase at any time. Okay? And there's a really sustained attack on these. There's a bunch of other cases I'm not listing here. We can get really into the weeds on this question. But basically, there's a line of cases that says if the agreement purports to say that the employer can terminate the employee at any time for cause, that in itself violates employment standards. Because there are times where an employee is protected from that, like if they've requested a statutory leave, or they've made a complaint, and you can't terminate them out of reprisal for making complaint under the Act. Okay, and there are other cases where the judges have agreed, well, that's a little too technical. It's not really about the time that they're terminated; it's the reason that they're terminated that matters. And so other courts have upheld those clauses. So this is all going to the Court of Appeal in Ontario, I believe this month, if not next month, March or April this year, where the Court of Appeal in Ontario will decide more definitively whether that language is appropriate to have in a termination clause, and what it decides will have an immediate impact on employment contracts around the country. Nova Scotia courts certainly watch these developments closely and have even followed them. And so what happens in Ontario in this little question, could easily render hundreds of employment contracts, thousands, unenforceable around the country. So it's something to keep an eye on. And if you're preparing these clauses, it's important to have them reviewed regularly by somebody who's familiar with the law in this area, because it tends to change quite often. And then I mentioned again in a bit more detail here this Dornan case from New Brunswick, where the CEO of New Brunswick Health Authority had a fixed term contract. And that's something we can talk about here, maybe. If you have a contract with a fixed term, where the agreement here was, okay, your term will be for 5 years. And if an employee is terminated in the middle of that, and there's no termination clause that articulates what's going to happen if that term is ended early, then by default, the courts will grant them the whole value of that contract. So in this case, that's what happened. The termination clause came in too late, wasn't enforceable because he got nothing in exchange for it. And so the court approved this employee being awarded the full term of his 5-year contract. He was terminated only a year into it. In his case, the total amount he was awarded was over $2 million. It also included aggravated damages because of the way in which he was terminated. which is something we can talk about too. But just the contract alone and the breach of it entitled him to a large amount of money, and all because it wasn't properly implemented. So that's important to keep in mind, this requirement to have fresh consideration. Okay, if you're introducing a contract in the middle of someone's employment, very important to get advice on how to do that and what can be offered. Something meaningful can be offered to the employee in exchange for the new terms. And if that doesn't happen, very likely a court's going to find that that contract can't be enforced, which is probably going to work to the employee's favor. So the bottom line there, if you tell a new hire to come in early because you're short-staffed and they end up signing the contract a couple of weeks later, it may not be worth the paper it's written on. Another little scenario here. This was a case decided just in December of last year, just a couple of months ago, by the Chief Justice of the King's Bench Court in New Brunswick. Here, there was a senior project manager who was working on fixed-term contracts, and he worked on 9 or 10 of them successively, just fixed one-year terms that kept renewing. So he'd sign a new contract at the end of each term. And at the end of the last one, the employer, there was a bit of back and forth. Relationship wasn't going very well for a few different reasons. But one of the things that happened is that the employer presented the employee with a new contract that was no longer for a fixed term. It was for an indefinite, open-ended term, right? No specific end date. You're now a permanent employee, is what they were telling him. But that contract had a termination clause in it. Okay, and the termination clause said, when you're terminated without cause, all you're going to get is the minimum standard under the ESA, it's called in New Brunswick, the Employment Standards Act. So the employee ended up deciding, I don't want to accept this contract because I was never subject to those terms before. And even though I was on these fixed terms, we all knew they were going to be renewed every year. It was kind of a fake legal fiction to call this fixed term contracts. Really, I already had an indefinite term arrangement with this employer. It was renewed virtually automatically every year. And now the employer is trying to introduce new, more onerous termination clause that benefits the employer, not the employee. And so he refused to accept those terms. And the court actually found, it's kind of an odd decision in some ways, but the court found the employee was constructively dismissed and awarded him 10 months pay. Okay. So what the employer thought it was doing was, presenting a new contract to offer the employee permanent work with a termination clause in it that was legal. And what it ended up doing was accidentally firing the employee and putting itself in a position where it had to pay him 10 months of reasonable notice pay. So if you're changing terms or introducing new contracts, it's just another example of what can go wrong in the middle of an employment relationship. One other subject I just thought might be worth mentioning for employers, I'll just kind of go on a bit here for the benefit of the people who aren't viewing it in real time. So there's a concept called inducement, and I think this probably does occur in the hospitality and restaurant industry fairly often, where an employee is not job hunting. Let's say they're a well-known manager in the industry or a chef or something, and they get recruited, right? The employer or their recruiter that they hire reaches out to this employee and says, hey, we have an opportunity for you in Halifax, up and coming new institution. You're going to be great for it. We'd like you to consider coming to work for us. The employee says, well, that's okay. I'm in a pretty secure position here in Toronto. I like what I'm doing. Don't really want to leave it. And then, the pressure stays on. They end up getting flown out for a visit. And at the end of the day, they end up agreeing to come and work for the new employer. And let's say, like in this case, the very recent case from BC, the employee is terminated after only a couple of years. And he's terminated without cause, not because he did anything wrong. So there, the new employer would owe the employee notice pay, and that how much they owe would depend largely on how long they had been working for them, right? But it's important to recognize that in these cases where an employee is induced to leave another job, and come and work for the new employer, um, at least part of their service with the old employer might be counted against the new employer, right? Because they're the ones who convinced them to leave that secure job, come and work for them, and then terminate them after a short amount of time. So the courts will often say, well, it's not fair to consider this person a 2-year employee because you recruited them from somewhere where they just worked for 15 years, right? So in this case, the employee with just 2 years of service was awarded 12 months notice pay. Okay, and that's something that can be dealt with in a contract. Okay, if the contract had explicitly said, you agree that you're coming here for a trial period, that none of your past service with your former employer is going to count for us for the purpose of termination or any other reason, right? This is the kind of thing the parties can agree to explicitly, but if they don't, the court might end up coming to a conclusion like this, okay, that some of the service to the old employer should carry over to the new employer for the purpose of termination entitlements. Okay, so I hope that's clear. I think that's a scenario that arises quite often too. And then lastly, it's important also to keep in mind that say you hire somebody and they're a line cook or a sous chef or a waiter server at first, and they work their way up through the business. Okay, and eventually they become a supervisor or some kind of manager. Maybe eventually they become a co-owner of the restaurant or something. Let's say they signed a contract when they first started the job, but they might have agreed to pay raises after that and new titles, but didn't sign any new contract. And if the original contract contained a termination clause, the question arises, well, does it apply? Does it still apply if 10 years later they're a manager? And so courts will say, well, that depends a lot on the facts, but if someone is just, naturally, say they're a server and they've been there for 5 or 6 years and now they're sort of the shift supervisor, they're supervising other servers, that's probably a natural enough progression in their job where the original contract they signed might still apply, right? The termination clause. It's foreseeable that someone who's got a bit of experience in the organization might end up supervising other employees who do what they used to do. What might not be so foreseeable is if they become, the general manager of the operation or a co-owner or something. So that can, if there's a dramatic change to their job, that can affect whether the original contract still applies, and that's called the changed substratum doctrine. That means the foundation of the original contract has changed so much that what was originally agreed to should no longer be enforced. So the simple lesson to take away from that is when people's roles are evolving, they're getting promoted, especially a dramatic kind of promotion, it's important to go back and look at the contract and consider whether it deals with that scenario, right? And if it doesn't, it's probably a good idea to put a new contract in place when the new responsibilities come into effect. So it's very clear to everyone, in this new position that this person has, what are the terms? Otherwise, you're kind of going to leave it up to a court to consider whether the changes to their position were so dramatic that the original agreement should no longer apply. One more point, and this is very particular to Nova Scotia, very important for employers to know about. Some of them are very familiar with it. Others we found are not. Under the Labor Standards Code in Nova Scotia, Section 71 contains a unique provision that no other provincial legislation has, and it says employees with more than 10 years of service cannot be terminated or suspended without just cause. Okay, so if you want to terminate an employee, you're not alleging misconduct, say just for budget reasons or something. If they have more than 10 years of service in Nova Scotia, Labor Standards Code says you can't actually do that. Okay, and what they can do is an employee with 10 years service can bring a complaint to the Labor Standards Division at the Labor Board, can bring a complaint and say, okay, I've been terminated without cause in breach of Section 71. And as a remedy, they can actually seek reinstatement. Okay, and the board will have a hearing about whether there was just cause. And if there wasn't just cause, one of the remedies that can be awarded is the employee can be reinstated to their position. And in the alternative, they can be granted damages in lieu of reinstatement, which can be equivalent to many months of their pay. Okay? And the reason this matters for employment contracts is that the Nova Scotia Court of Appeal has said, well, if you have a termination clause that doesn't account for this, it's not enforceable in Nova Scotia, right? So if this case that's referred to on the screen here said that if there's a termination clause that says, okay, we can terminate you at any time without notice, by providing you pay in lieu of notice, up to 26 weeks or something. And that's all it says. Well, it doesn't actually tell the employee that under Section 71, if they work there for more than 10 years, that can't happen, right? The employer is not allowed to terminate them without just cause. So the employment contracts in Nova Scotia, to be really strong and enforceable, need to account for that somehow. And that's pretty critical. That would be a reason to strike down a clause regardless of how long the employee actually worked in the position. So that can make these contract clauses in Nova Scotia fairly tricky, actually, to comply with the code because of that little twist. So those are just some key takeaways on employment contracts. I think that it needs to be appreciated that a clear employment contract is usually pretty valuable to the employer, provided it's done properly, it's drafted properly, it's implemented properly, right? That the clauses are specific to Nova Scotia and they're not just drawn from Ontario Friends examples or ChatGPT might have written them, right? That tends to get people into problems, particularly when they don't know what to be asking for, right? How to make the contract compliant with specific provincial legislation. Important to avoid certain language, like at any time, important to provide fresh consideration, important to remember the 10-year rule, important to think about what happens when you're inducing employees to come work for you from another restaurant or from another organization. And important to get legal advice at the time of hiring and also at the time of termination at the very least. So those are some basics we thought would be helpful. Maybe turn it over to my colleague Kelly here to see if he has anything to add to any of that. But I think those are the basics that you need to know.
I think that's right, Dan. I think those are key points for every employer to be aware of and to cover. Something that employers often concern themselves with, I think, is whether or not an employee will, be put off by an employment contract in the same way that, say, a prenuptial agreement in a marriage situation is not always the most popular discussion to have. But our experience in many employment contracts with many different employers is that employees typically do not have a major opposition to entering into an employment agreement that is written. In some cases, employees actually feel better about having an employment agreement that is reduced to writing. And I think it does help sort out a lot of complications later on in the employment relationship. So I think what Dan's covered are some of the key common mistakes that employers make. And our goal is to try to help flag those mistakes so that people don't have to make them. They can still obviously feel free to make those mistakes, but what happens from our perspective is that those mistakes end up costing not only money, but they cost a lot of time and a lot of stress later to fix. And so a well-drafted employment contract can act as a kind of insurance policy, I suppose. But, as is the case with insurance, some people decide not to get it. And even if you don't have insurance, you could operate without it for a long period of time and feel like it's pointless. Automobile insurance is a good example. You could I suppose, choose to drive your car without insurance. It's against the law, but you could do that. But you might never get in a car accident, and so you might think, gee, I would have been wasting my money if I had bought insurance. And the truth is, you wouldn't be. You would just be operating, I guess, out of luck. And that's the way it is with employment contracts. So those are good points, Dan. We should talk briefly about psychological safety in workplaces too. This is an area that we have been really fortunate to be involved in for a long time. And I think that's partly because we've done a lot of academic research into workplace conflicts and conflict management, not only here in Canada, but also in the United Kingdom. And so years ago, when other jurisdictions became interested in this legislation that has only recently been adopted in Nova Scotia, other jurisdictions started to study the subject, and just by good fortune, we were involved in those discussions and ended up doing a lot of work in this field in not only New Brunswick and Prince Edward Island, but also Ontario and Alberta, British Columbia, and in the United States. So we've had, I suppose, the good or bad fortune, depending on how you see it, to be involved in lots of workplaces where psychological safety policies and regulations have been called into action. And so we'll talk for a few minutes, if that's all right, about some of the common issues that come up, and then what the new regulations in Nova Scotia mean for employers. Basically, as everyone can appreciate, the psychological safety legislation in Nova Scotia is very similar to the legislation that now exists in each jurisdiction across Canada. In other words, every province and also the federal government have now passed this kind of legislation, which is meant to address a couple of key misconducts in workplace, one of which is sexual harassment, and the second of which is non-sexual harassment. The legislation will also address violence, and we'll talk briefly about that too. But the two misconducts that are most commonly addressed in the legislation and that most commonly arise in workplaces are sexual harassment and harassment of a personal nature. So first, if you remember back to 2017, that's when the hashtag Me Too movement emerged, and it was on one of the awards programs right around this time of year that the hashtag Me Too movement really became most popular. But of course, sexual harassment predates 2017 by some long period of time. And so it was only, though, in the last 10 years that employers and governments started to recognize the devastating impacts of sexual harassment and also personal harassment, not only on the individuals who are the victims, but also on bystanders in organizations and ultimately on employers and governments. So what's often not spoken about, because it's less important than the impacts on the victims, but nevertheless worth mentioning, is that in any organization where this kind of misconduct is allowed to fester, then we will see psychological injuries cause to the victims of the behavior, but also psychological injuries often cause to co-workers, bystanders who are seeing this happen. And then the impacts cascade through organizations to the point where that misconduct allowed to occur has impacts on employee citizenship or commitment to the organization. It has impacts on organizational productivity. It has impacts on the ability of organizations to recruit staff and to retain staff. And then it has a significant impact on the society through government, because psychological injuries require medical attention, and we simply don't, in most Canadian jurisdictions, have the resources to actually address the extent of the needs that exist in the society. For example, a recent statistic from the Canadian Mental Health Commission indicates that somewhere north of 25% of the demographic between ages 25 and 40 have a mental illness of some kind. And so adding to that, statistic is not helpful to the whole society, and certainly not to employers who are already constrained in the workplace by limited ability to access the kind of workers that they need to operate their businesses. So as frustrating as this legislation or any legislation can appear at first glance to an employer, this is actually beneficial to employers if it's done right. So here's what it requires in a nutshell. First, it requires employers to be aware of the fact that workplace harassment, including sexual harassment, is broadly defined. Second, it is almost universally not dependent upon intent. And that's because if a particular behavior which constitutes harassment or sexual harassment it has a negative impact on a victim, whether or not the perpetrator, the wrongdoer, intended that impact to occur is irrelevant. And the reason we have to think of it that way is because otherwise it would become too difficult to regulate or stop the behavior. And stopping the behavior is the key issue. So it's broadly defined. It is not dependent on perpetrator intent. It does, though, attract attention toward behavior that is degrading, belittling, that it affects a person's mental well-being, generally speaking. So here are some examples you see on the screen. Spreading rumors, making false allegations, gossiping. We've met with employers and done training for employers all across Canada and into the United States, and one large employer in the United Kingdom as well. And in the course of that, we've met with certainly 10,000 employees, and actually more than that. And in all of those discussions, it's been really clear that gossiping is quite a common occurrence in workplaces, no matter what industry they're in or where they're located geographically. But gossiping is often a form of bullying. Undermining work is a form of bullying, or can be. Changing expectations of an employer, that's an employee, sorry, can be a form of bullying. Removing responsibilities, blocking applications that an employee might make for training or promotion, assigning unreasonable duties, or even ostracizing an employee. And this is another example that people don't always think of as being bullying, but it is. In fact, in a study that was done in the OECD back in 2015, there was an assessment of the top 73 countries in the world in regard to school-aged bullying. And Canada actually proved itself to be a fairly adept culture for bullying. People are often surprised by that, but in the OECD study, Canada ranked 7th in the world for the most bullying amongst school-aged kids, more than the United States, actually, which surprises many Canadians and disappoints many Canadians. But one of the forms of bullying that is prevalent in schools is social exclusion or ostracization, and that occurs in workplaces as well. And so that's one of the forms of bullying that employers are required now in Nova Scotia to regulate against. So things that don't constitute bullying, as you can see on the screen, are, for example, reasonable performance management, reasonable scheduling decisions, and operational direction. In our line of work, representing a lot of employers, we see many of these cases, and in some cases, employees will allege that their manager has bullied them. But when you dig into that allegation, what really has happened is that the employee has perceived bullying because the manager is providing the employee with direction. There's nothing wrong with reasonable performance management. And that's only logical. If your employee isn't performing well, you have to tell them that. Telling them that is not bullying unless, of course, you do it in an unreasonable way. So if you say to your employee, look, Kelly, you're not meeting our expectations, and here are the reasons why you're not meeting our expectations. And as a result of your failure to meet our expectations, your performance review will be weaker than you might have hoped. That would likely be a fine, way to express a difficult piece of information. If, however, you say, Kelly, listen, it's clear to us that you're really a bit of a numbskull and you don't really, have the intellectual capacity to do this job because, and beyond intellectual capacity, it's clear to us that you're, as lazy as a cat, and and as dumb as a fence post, and all of those things, then and if further maybe you have that discussion in front of a whole group of coworkers, then that would be unreasonable performance management and likely would constitute harassment. So what we see is that employers struggle with first being able to identify what constitutes harassment or not, and then more importantly, how to deal with it. One of the things that we see very frequently, and we would encourage employers to think about, is training managers to have the difficult conversations that it takes to call into question bullying behavior. If you call it into question early enough, it actually can save employers a lot of time and a lot of resources. More importantly, it can save individuals from being psychologically injured. But in order to call the behavior into question early, you have to train managers first on how to identify misconduct. And secondly, you have to give managers the tools and the skills to be able to address the misconduct quickly and effectively. So on the screen, you'll see one of my favorite cases with respect to bullying. It's the case of Meredith Boucher and Walmart Canada. It occurred in Windsor, Ontario, back in the early 2010 to 2013 period. And in this case, in a nutshell, Meredith Boucher was an assistant manager at Walmart. She was asked to move from one Walmart store to another. At the new store in Windsor, she was under the management of a guy named Jason Pinnock. Pinnock asked Meredith Boucher to effectively fudge the cooler temperature logs in the grocery department at Walmart. And she refused to do that for good reason. But when she refused, it had a negative effect on Pinnock's performance rating as a manager because he had a number of corporate metrics that had to be met in order to get his bonuses. Not having these cooler temperature logs filled out properly was problematic for Pinnock. And so when Meredith Boucher refused to fudge the cooler logs, Pinnock went on this campaign of belittling her in front of other staff and sometimes customers. This happens, doesn't it? Because really it engages a larger discussion about how human beings deal with power and authority. And in the case of Pinnock and Boucher, Pinnock had the power. He misused it by belittling her. And he belittled her because she was not, in his mind, demonstrating the requisite sort of respect for him and a willingness to do what he said, regardless of whether it was appropriate or not. And so she ended up with a psychological injury. And I think the judge in the case describes it very well and in a graphic way that illustrates how these kinds of interactions can affect human beings. The judge described, for example, that Meredith Boucher was injured to the point where she experienced sleeplessness. She experienced symptoms of depression. She experienced vomiting of blood because of the severe stress and anxiety that she was under at work. This is because she was being regularly exposed to misconduct by Pinnock. She could never really know for sure when Pinnock might come around the corner and make fun of her, belittle her, be angry at her. And so that anxiety that she was experiencing regularly caused all sorts of psychological and physical symptoms. In the trial division, Justice McIsaac awarded about $1 million in damages against Walmart and $500,000 against Pinnock personally. I think that's a real good takeaway for managers on an individual basis, because it's one of the first cases in the country where an individual manager was sued personally and successfully for having bullied a coworker. Walmart was sued successfully because not only had it incurred vicarious liability as a result of Pinnock's misconduct, but secondly, Walmart had failed to properly regulate its own workplace. It had failed to implement a proper system to address bullying. And when the complaint of bullying was brought forward by Meredith Boucher, Walmart had an investigation team look into the allegations. They not only concluded that Pinnock had not bullied Meredith Boucher, but they recommended that Boucher be disciplined for making up a false allegation against Pinnock. And this happens frequently too, less so now than 5 years ago, but still it happens that employers will hire external investigators who aren't well versed in the skills needed for investigation, or employers will have an internal person do an investigation when the internal person isn't qualified to do a proper investigation either. And in those instances, the failed investigation or the flawed investigation can attract additional liability to the employer. So I think what that tells us is that you have to have, as an employer, not only a well-drafted policy against harassment and sexual harassment, but also more than that. You have to have competent, effective training programs. You have to have competent management that can identify when violations of your policy are occurring. And then you have to have the ability to effectively and competently investigate these violations. So what that means is, with regard to the Nova Scotia legislation that was just implemented in late August of 2025, every employer should now be putting in place a respectful workplace policy. The good news is Nova Scotia was the last jurisdiction in the country to pass this legislation, and so therefore every other jurisdiction in the country can provide some good models for policies that employers can implement. Secondly, and I would say this too, Dan mentioned, AI in the discussion about contracts. AI is a go-to resource, I suppose, for some people on a lot of different subjects. And it could be for a policy, a respectful workplace policy. But the key is to just be really careful with whatever resource is being used, because first, it may be flawed inherently, but secondly, it may not be exactly what it could be for your organization in terms of a tailored, specific policy that addresses your workplace circumstances. And I think people in business people should see this as an opportunity to maximize the effectiveness of your workplace. It's like coaching a sports team or conducting an orchestra. You can have the team, you can have the orchestra, it can be doing okay. That doesn't mean it's optimized for success. And these policies actually do help optimize organizations for success in very complex ways that we won't talk about today, but that we have some familiarity with. On that point, by the way, we've had the good fortune of doing these exercises with sports organizations and with music organizations, including orchestras. There's a famous movie about bullying in a music school. But for anyone who's interested, they should look up some of the bullying experiences in professional orchestras and symphonies. It's really it's really quite prevalent in that culture. And the reason it is, or one of the reasons it is because those are cultures that are dependent on expertise, skills, and they demand perfection. And in those environments, there tends to be a very high prevalence of bullying. So what I would say, though, is for every business person, like a coach of a professional hockey team or the conductor of an orchestra, the real question is, does your organization perform at its highest level? The answer is probably no. And these policies that are being discussed in the Stronger Workplaces for Nova Scotia Act are actually policies that could help elevate every organization's effectiveness and productivity. That's a byproduct of making sure that your workplace is psychologically safe. So, again, we won't get into that research, but it's fascinating. So when you draft a policy, then look at the legislation in Nova Scotia, consider some of the precedents that are in existence from other jurisdictions, but make sure that the final document that you create and that you implement is tailored to meet the requirements of the legislation in Nova Scotia and the specific circumstances of your workplace. Secondly, look at training. And I'd like to speak about this for a moment too, please, because there is this thought that, respectful workplace training is, kind of a statement of the obvious. I've heard that many, many times in many jurisdictions where people will say, look, I learned how to behave properly when I was 3 years old, and my parents taught me that, and I'm a polite person, and that's that. Sure, but that doesn't mean the person sitting next to you learned the same things in the same way. And of course, when you layer on complications like the high prevalence of mental illness in workplaces, the introduction of different cultures in workplaces, when you introduce the high stress and pressure that exists in certain workplaces, for example, in restaurants, all of those are variables that will tend to promote bullying and harassment. Stress, for example, and tension or pressure is a very well studied factor in devolving human behavior. So those things can be outlined in a policy. And then with training, you have to question whether you are adopting the most effective training program. It's easy to find a training program that's online and is like a check the box training program. Your employees will pay a few dollars, or you'll pay a few dollars on behalf of your employees to go through the training program. They'll either listen to it or they won't. They won't be highly engaged, and it probably won't be very effective. In fact, there is a body of literature that tells us that poorly constructed training programs actually elevate occurrences of harassment and bullying in workplaces. The very training that is designed to reduce that behavior causes more of it, which is clearly self-defeating. But what that tells us is that you as an employer can do a better job than some other employers in designing and implementing training. This is something we've studied pretty extensively, and what we've concluded and what we do and others who we think are very effective in this field do is implement training that involves interaction, that involves discussion, that allows people the opportunity to not only speak about their own experiences, but to hear the experiences of other people. There are some tools that we use to facilitate that discussion, but that's the kind of discussion in a training program that will typically elevate the outcome of the training itself and make it worthwhile for not only employees of an organization, but also the organization itself. And so we encourage people to think about that. In addition to training, you have to include in your policy some proper structure for how to make a complaint and how the complaint will be investigated. And so those things should be addressed in the policy, but more importantly, or at least as importantly, every employer should make sure they've given serious consideration to those two elements, because if your complaint process isn't well received by your employees, people won't make the complaints. If they don't make the complaints, you shouldn't think you're doing a good job and that, that's the best outcome. It's a little bit like, I always think it's a little bit like finding out that you, like not going for a regular checkup to your doctor. You're never going to get bad news, which may sound really good and may feel good until you find out that you have 3 weeks to live. It's better to have people complain. I know that sounds counterintuitive, but guaranteed it's better to have people complain, because it gives you as the employer the opportunity to identify what the alleged problem is, to determine whether it's a problem or not, and then to control how it's addressed. It actually puts the control back into your hands in the same way that early detection of cancer or some other illness through investigation by your doctor gives you more options, more opportunities. And so we think that that's a missed opportunity for some employers. And just for the record, like we trained about 8,000 employees in a very large Ontario organization a few years back. And we went to all the locations that you could imagine in Ontario, from Toronto and Ottawa to Thunder Bay and Timmins. And I think there was a concern in that organization initially that there would be an onslaught of complaints, and there was an increase in complaints once the training occurred. Our comment to the employer was, of course, there's an increase. If there wasn't, we'd be pretty disappointed, because we'd know that nobody was listening, because the training was all about, how to complain, how to bring forward these concerns. And so that was, that was a slight increase, but then what the organization experienced was a steady decline in complaints. And that's because they were becoming much better as an organization in addressing behavioral concerns in workplaces. Their managers were becoming more competent in identifying problems. Their managers were becoming more competent in receiving and addressing complaints. Their investigation team was becoming more competent in, investigating and examining allegations. And overall, the organization was becoming more effective in its discipline and basically its handling of misconduct. That's like a gold standard outcome for an organization, because if you have more than one person in your organization and you believe sincerely that there's never any bullying or any harassment happening, I would have to question you deeply on that, because there just has to be misconduct happening in your organization. It's human nature. So the more that misconduct can be addressed at an early stage and identified and corrected, then not only do your liability risks drop as an employer, but more importantly, the health and safety of your employees increases. And the literature tells us that that should have a positive impact on overall organizational productivity. So it's a win-win for everyone. So those are some of the steps that are required under the new legislation in Nova Scotia. It's been tried and tested across Canada before being passed in Nova Scotia. So, there's no need for any employer in Nova Scotia to feel like a guinea pig. All the guinea pigs are in Ontario and in the Western provinces. A couple of things that the legislation seeks to prevent, whether in Nova Scotia or any province, are these examples, or these are the ones that we think are the most extreme examples. First, the OC Transpo massacre. That was a case back in '99, and the guy at the center of this case was a fellow named Pierre Lebrun, who had a speech impediment, and he was teased by his coworkers. I spent some time with the then security manager of OC Transpo in the years after this occurred, this very tragic event. And what I learned was that Lebrun, with this speech impediment, was going to work. He was a bit of a loner, and his coworkers would tease him about the speech impediment. Lebrun asked them to stop teasing him. As is human nature, they didn't stop teasing him. In fact, the request to stop just elevated the teasing. Lebrun went to the HR department and asked the HR department for help in stopping the teasing. That didn't happen. He eventually said to one of his coworkers in this bus garage where he worked, he said, "Look, I could pick a number of you guys off in here." And, the guy said, "Well, yeah, I guess you're probably right, Pierre." And he did not report that comment that was made by Pierre Lebrun. In a few minutes, I'll tell you why that became important. But Lebrun reached his breaking point. He wrote a detailed suicide letter to his parents. And in that suicide letter, he talked about the fact that he had sought help in stopping this bullying and that no one had helped him. And then he wrote a line that I've always thought was pretty impactful. He said, "I'm not going to let these guys get away with this anymore." And then in April, so right around this time of year of '99, Lebrun went to the bus garage where he worked with a rifle. He shot 4 of his coworkers and killed them. A couple of them were young parents at the time. And then he killed himself. And the story got a little bit worse than that, again, if you can imagine, because the person I mentioned to you a few minutes ago, the guy that Lebrun had said, "Hey, I could pick a number of you off in here." The guy that Lebrun said that to, about a month or so after this massacre, he also killed himself. And he wrote a suicide letter to say, "Look, I can't deal with the guilt anymore of not having said something." And that's another reason why training is so impactful, because it gives people the opportunity to understand that they can, help contribute to a much safer workplace and to help avoid these kinds of tragedies in their own workplace. The second case that we think is so impactful is this Eric Donovan case in Prince Edward Island. Donovan was a guy that worked in a group home in Queens County in PEI. He got injured when he was helping or addressing like an adult resident of the group home, and basically Donovan's back ended up injured in this interaction. And Donovan was like a athletic guy, but he had this back injury, and his manager at the time, a female, was very dismissive of his back injury. She made fun of him repeatedly about the back injury, and made a number of comments that it caused Donovan to feel that he was being seriously demeaned and belittled, in much the same way that belittling had a physical effect on Meredith Boucher in the Walmart case that we discussed earlier. This belittling that Eric Donovan felt had a physical impact on him. And what happened is, in about October of maybe 2013, he went home from work. His wife, Lisa Donovan, said, "Look, Eric, something seems off with you. You don't seem right." That's when he explained to her what was happening at work. She suggested that he should stay home until this could be sorted out. He agreed, but it was that night, I believe, she went down to the grocery store, and when she came home, he was collapsed on their kitchen floor, and he was rushed to the hospital, the QEH, and died in the hospital a few days later. And medical professionals attributed the heart problem that he was experiencing to this stress in the workplace. So that's yet another reason why every employer has this great opportunity, in our view, to, create a system that will include a policy, but will go deeper than that into training and remediation. Those are all health and safety benefits that come from this legislation. And we think that for employers, it's such a good opportunity to maximize your health and safety protocols in your workplace, recognizing, though, that doing those things increases psychological safety. Increasing psychological safety has a positive impact on all of those issues that I mentioned a while back, including employee engagement and citizenship, productivity, collaboration, cooperation. All of those things are beneficial in a workplace. I'll mention incidentally too that we see a lot of cases where workplace harassment and bullying result in sick leaves and absenteeism. It's really common. And so once again, that experience causes employers, losses of a variety of kinds. And so if you can reduce absenteeism, for example, by implementing a really effective program under this legislation, then you save yourself organizationally, in addition to benefiting the well-being of your employees. So it just strikes us as being all the way around a positive. It does take some time. More important than time, though, it takes discipline. We've seen some organizations that I dealt with an organization in California that had the right policies but didn't implement them the right ways. And there was this sexual harassment circumstance that arose in the workplace. When it arose, that was one problem. Then the employer didn't handle it properly. That was a second problem. And and by not handling it properly, it became a, you know, like an open discussion point in the workplace. That was a third problem. And then the fourth problem was the person accused of the sexual harassment ended up, because of the fact that it was now like a common discussion point in the workplace, the fellow who was accused of the sexual harassment committed suicide. And that was obviously another devastating problem in the workplace. So those are all things that the legislation seeks to avoid. For members of the association, we hope everyone's getting some help on this. Everyone probably has their own lawyers. If they need help, they can feel free to call us, because we'd be happy to help, but we're not, trying to drum up business, but we're certainly happy to help if people don't have someone to help them already. Dan, what did I miss?
Oh, I don't think anything was missed there. I mean, we could go on all day about the possible legal potholes you could fall in these things, torts of intentional infliction of mental suffering, constructive dismissal claims, human rights claims. There's all kinds of angles this can take in now, with occupational health and safety explicitly covering psychological safety in Nova Scotia. That's just yet another legal sort of hazard in an already legally hazardous environment. So I think that really all just scratches the surface. And as Kelly said, I think on both these issues, with employment contracts and respectful workplace policies, which kind of interact with each other and kind of go together, these are the kinds of things that every employer, service industry or otherwise, should be thinking about seriously, and making sure that they have some tailored, a tailored and informed approach to the reality of their own workplace.
Thank you so much, Kelly and Dan, for sharing your expertise on contracts and workplace psychological safety. It's something that, it could be fraught, I think, in any workplace, as you said. And I really appreciate especially the summaries of the key takeaways, because some of them, like the ChatGPT reminder, like, hey, that's not maybe going to give you all the information from Nova Scotia. It might be Ontario. And like the understanding that while, yes, the restaurant culture can be, you can't use that as an excuse. We're like, oh, this is restaurant culture. It's like, no, you have developed this culture. This is something, as you said, like the employee citizen buy-in needs to be addressed. So thank you so much for sharing your experience. And thank you Tina for attending, and anybody who's watching this online later.